I'm reviewing the fantastic and eloquent decision by the Court of Appeals of the Fifth Circuit, striking down the arguments of these social media companies, their justifications for censorship, and upholding the Texas law that restricts this kind of censorship. Here's the court. Section 7, they're talking about Section 7 of this law, does not chill speech. If anything, it chills censorship. The court goes on to say it does not regulate the platform's speech at all. It protects other people's speech and regulates the platform's conduct. Now, in a very sneaky way, these platforms basically say, well, this would chill our right to free speech. We have a right. Doesn't Twitter have a right to free speech? And essentially the court argues, sure you do. If someone, let's just say Debbie D'Souza, posts on Twitter and you don't like it, Twitter can post something saying the opposite. Twitter can post something criticizing Debbie. Twitter's free speech is not restricted. It's not as if Twitter has limited space. Oh, Debbie's taking up space. There's no space for Twitter to respond. Twitter has all the space it wants to respond. Twitter has all the space it wants to exercise its own editorial judgment. The court says, we're not stopping Twitter from saying anything. We're merely saying that Debbie, as a resident of the state of Texas, has the free speech right to post on Twitter, post on YouTube, post on Facebook, without being kicked off if she's not saying anything unlawful. Now, the other point here is the court is drawing a distinction between speech and conduct. The court is saying that the act of censoring someone, kicking them off the platform, is not speech. In fact, what is it? It is conduct that restricts other people's speech. So the court is distinguishing between Twitter's right to free speech, which is unaffected, and Twitter's conduct in taking people off of Twitter, banning them, removing them from the platform. Now, no surprise, the social media platforms pull out, well, let's call it the Nazi card. And here, looking at their brief, they talk about, quote, we should be able to censor pro-Nazi speech, terrorist propaganda, Holocaust denial. This is the good old, let's call it the appeal to extremes. Hey, listen, if we're not allowed to kick people off for what they say about the vaccine, and we aren't allowed to kick people off because they deny that the temperature is changing due to some kind of human action, then we won't be able to stop the Nazis. What did the Nazis want to get on Twitter? And the court basically says, first of all, you're not censoring Nazis. You're censoring all kinds of people who are far from being Nazis for just because they disagree with you. The court actually gives example. You've censored athletes. You've censored celebrities. You've censored people you've censored elected representatives. You've censored congressional hearings. You've censored state hearings. So the court is totally unconvinced by this kind of, let's call it the Nazi song and dance routine, which the court calls, quote, an endless stream of fanciful hypotheticals. In other words, this isn't Nazis who are claiming the right to free speech. This is ordinary citizens all over the state of Texas. The court basically says that the First Amendment goes through a kind of history of the First Amendment. And the basic idea here is it's the freedom of citizens to make well-intentioned statements of their thoughts on any matter of public concern. Now, by the way, it should be really clear, and Debbie and I were talking about this over our coffee this morning. Debbie was like, when people are talking about COVID or talking about climate change, they're not making statements of misinformation. It's just that the left doesn't agree, so they call it misinformation. So in other words, the left is saying, you're stating matters that are not facts. You're stating matters that are not facts about the 2020 election, Dinesh. But the point is that the First Amendment, by the way, draws no distinction between facts and values. The First Amendment doesn't say, well, Dinesh, you're entitled to state erroneous opinions, but you're not entitled to state erroneous facts. The fact is, you are entitled to state erroneous facts. The First Amendment protects erroneous statements of fact. It's really important to realize the First Amendment makes no such distinction between factual statements on the one hand and you may say statements of opinion or preference on the other. The First Amendment protects both. And so what the court is doing here is just ripping out the ground from censorship. All these kind of bogus rationales. Let's even say that someone was stating flat out misinformation. Oh, I'm looking outside my window and the sky is green. In fact, the sky is blue. That is protected fully under the First Amendment. I should be able to go on Twitter and say that the sky is green or the sky is yellow or the sky is whatever. I have a First Amendment right to say that. I could be wrong. I am wrong, but it doesn't matter. I still have the right to say it. So this is really the meaning of free speech. And the court is ruthless in slamming these guys for trying to violate it. The court basically says, listen, we reject the platform's efforts to reframe their censorship as a form of speech. It is undisputed that the platforms want to eliminate speech, not promote or protect it. No amount of doctrinal gymnastics can turn the First Amendment's protection of free speech into a protection of censorship. Boom. So this decision resonates like this. I'm not even done with my analysis of it. I'm going to pick up the important theme tomorrow of whether these platforms are, quote, common carriers. I'll discuss that in more detail tomorrow. But you get a sense here, the sort of thunderous way in which the court is smacking down these social media platforms. And I suspect that if they go to the Supreme Court, they will get another resounding smackdown.